to enter into a relationship where you are already married. So this doesn't matter whether you think that one is going to be a marriage and one is going to be a cohabiting arrangement. It technically doesn't matter, although it hasn't been prosecuted very heavily. You, your spouse, your religious leader who has contracted this, everybody can be punished with up to 5 years in jail. So it's not just like a fine. It's a big deal. Not only are there criminal consequences, there's also family law consequences, right? So she's not going to have her civil law rights if she is going to perhaps desire a divorce later. She's not really married. Even if she thinks she's married under religious law, if she knew that she was entering into a relationship where the other individual already had a spouse, her marriage is just not valid. The only way that the polygamous marriage can give some rights to women when they are seeking divorce is if she did not know her husband was in an existing relationship, or if she entered into that polygamous marriage in a country that does recognize polygamy. And even then, there's some limitations about what she's exactly entitled to. But if you are two individuals living in Canada, in general, you're not going to have any types of rights. However, like I said before, child support responsibilities, they follow irrespective of what type of relationship you enter into. So just like I said before, how even with married couples and with common law couples, also polygamous couples are going to have their child support and other responsibilities. These types of things aren't dependent on the status of the parents. It's dependent on what's in the best interest of the child all the time. So now that we've talked about the different types of relationships, let's talk about what you can do to protect your rights. So there's a term called domestic contracts. Now, every province has different rules about how to make them, but essentially they all stem from the idea that anybody can agree to give up their rights. So this means that both outside of family law and within family law, we allow people to sign away their rights, right? But if you're going to do so, you have to do it in a certain way. So there's 3 types of ways that you can contract into or contract out of certain family rights in Ontario. There's a cohabitation agreement. So like I said, these are for common law partners who aren't actually married. Then you have a marriage contract. Those are for people who are actually married. And then you have a separation agreement. So this is for either or. So the cohabitation agreement and marriage contract are similar in that they are both designed to protect your assets usually. You both enter into them either before or during the relationship. So sometimes a marriage contract is known as a prenup or a prenuptial agreement. That's usually when it happens before you get married. You can also do it after you get married. There's nothing to prevent you from doing that. So if you got married and you didn't have time to do a prenup or you forgot to do it, there's nothing preventing you from entering into a marriage contract during your marriage. The separation agreement, that's when you are deciding on how you're going to split ways with your partner. So that's something that you do, whether you're in a cohabiting agreement or a marriage contract, you can do a separation agreement afterwards as well. So there are some limitations and some restrictions about what can be made. But in general, I'm just going to focus on marriage contracts because they are similar to the cohabitation agreement. And we are going to talk about separation in a later session. So like I said, for marriage contracts, you can do this before or after you get married. And usually some of the motivations that people are going to have that's going to make them want to enter into marriage contract is if they have a lot of assets, because like I mentioned earlier, when you enter into a formal marriage relationship and then you want to leave that relationship later, the division of property and assets, all of the debts you accumulated together, all of the assets you accumulated together, those are going to be shared together upon divorce. And so assuming that one person brings in a lot of assets, they might not want to, they fought hard for it, or maybe it's something special, like it's a family cottage. They don't want to give away that upon divorce. So that's a very common and frequent reason to motivate somebody to enter into this type of contract. And you can agree on that, right? So you can say that upon divorce, we won't be doing what the typical marriage law may entitle towards, and instead I'm going to keep this property, or he's going to keep that property. You can also decide on things like spousal and child support. So you can decide on how much money and when. And you can even decide on the education and the moral training of children, right? So you can say that upon divorce, my child is going to remain Muslim. That's something that you guys can agree on before you even have kids. However, there are certain restrictions on what you cannot include, especially when it comes to your children. When it comes to your children, you cannot decide in advance who's going to have custody or access. Now, these terms are actually changing. So while, at least in Ontario, and I believe in other provinces, custody and access are no longer being used. So custody is now being referred to as decision-making responsibility, which makes it a lot easier to understand. It's essentially, the parent who is making decisions for the kid. Can he go to a soccer game? Can he do this? Can he sleep over at his friend's house, right? And then you have access. Parenting time is what it's being called now. So I put the terms in there for your reference about what a lot of individuals still refer to these two types of parental rights as, but they are now being called parenting time and decision-making responsibility. So like I said, these are things that you cannot contract into. You can't say, for example, that even before I even have a kid, I'm going to say that when I do one day have a kid, I'm always going to have access and you'll always have custody. It doesn't work that way. Why? Because like I said before, these are decisions that are made in the best interest of the child. You don't know those things until the child is born and until you have the child. And so those decisions have to be made at the time of separation. So while a separation contract, so if I go back a slide, to domestic contracts, we had this third one, the separation agreement. Under the separation agreement, you can decide on custody and access issues, but under the other two, you cannot. Other things that you cannot decide on in a marriage contract is changing their equal right to live in the home. So I said before that you can decide on the financial value of the home and how that's going to be split up. So maybe half of the home's value shouldn't go to one person and the other. Maybe you guys want to say, you know what, you get to keep the value of that home. However, you can't say that as soon as we're getting divorced, you can't live here anymore. That's something that you cannot contract out of in a marriage contract. And then there's two other things that a court will just not enforce them if you include them. One of it is saying, if you remain chaste, then I'll give you X, Y, Z, right? That's not something that is enforceable in a court of law. And it's just, even if you put it in your contract, it's not gonna have any teeth to it. The other thing is you cannot say, if something happens, if somebody's going to give me the mahir, then I will give a religious divorce. You cannot condition anything on a religious divorce because a court cannot force somebody to give a religious divorce. It goes against the idea that a court can't force religion upon somebody, right? Even if they've consented to it. But what a court can do is they can penalize somebody for breaching something they promised to. So the distinction there is, let's say somebody does say that I promised to give my wife a religious divorce, and then he doesn't do it. Right, the court will not be able to force the husband to give that divorce, but the court can, for example, financially penalize the person when they're applying for different types of applications in court. So it's not, that contract provision does have a little bit of teeth to it, but it's not going to actually be implemented in the way that it's written, right? Even if it's part of a domestic contract, ultimately courts in Canada cannot force a person to give or get a religious divorce, but they can pay money for breaking a promise. And so that's the distinction there. The next thing we'll talk about is the enforceability of marriage contracts. So you can't just write on a piece of paper, in your kitchen and say that this is what we agreed to. There are some rules about how you can make sure that your agreement is going to be enforceable in court. Every province is different. They essentially have to be dated, witnessed, signed, and usually these are done with a lawyer. The reason is it's done with a lawyer is not only do they understand the conditions to make it enforceable procedurally, but it's also a requirement that each person, both partners, husband and wife, get a lawyer. Each of them get a lawyer. So the husband gets their own lawyer, the wife gets their own lawyer. And this is really important because when you do get independent legal advice, it's what it's called, ILA, it's sometimes referred to, you'll actually be able to understand what you're agreeing to. It's really important to not just give up rights. Sometimes, we're all very excited to enter into the beginning of a marriage relationship. It's not always pretty to talk about, what's going to happen upon divorce, but it's really important that you understand what you are signing away, because even if what you signed to is unfair. Maybe you said that I don't want any money, I don't want any spousal support, I don't want any assets that are at divorce. Maybe you signed away to all of that. The court will still uphold that if because the court wants to make sure that people are responsible agents and they're deciding for themselves. So you really have to make sure that you're getting this independent legal advice. The lawyer will be able to tell you, this looks very unfair. So maybe you shouldn't be signing on to this. Or maybe, the lawyer won't persuade or dissuade you, but they'll just tell you, this is what you would get if you weren't entering into a marriage contract. And this is what you're getting if you are signing. So getting a lawyer isn't going to prevent the process, not going to make it go slower. It's not something you should be afraid of, but in fact, it should be something that you really want. Because if you don't do this, and if you don't take this step to get ILA, you won't be able to argue later that you didn't understand your rights when you signed the agreement. And it's very possible that the court just won't enforce it. Because having ILA means that the process was fair at the end of the day. It's one of the ways that you prove to the court that nobody was forced, everybody understood what's happening. One of the other things that sometimes makes contracts unenforceable is if people lie to each other, right? So if one person was a millionaire, pretended to only have $100 in their pocket at the start of marriage, that's going to change whether or not the other person wants to sign on to a prenup or not, right? These are types of things that make the process unfair, and so it can make a marriage contract unenforceable by the court. So we'll talk about Mahir now. Mahir is a type of agreement where the husband promises to pay his wife if the marriage ends or if he dies, right? So this is something that is frequently known as a dowry, right? It's something that's very common in Muslim marriage contracts, and sometimes people are confused about how this fits in with the local law. So can a mahar be enforced as a marriage contract? Yes, it can, if it meets those standards, like I said, that it has to be in writing, signed by both parties and witnessed. Signed by both parties means it's signed by the woman and the husband, right? Not the woman's father, not her uncle. It's signed by her and witnessed. And it should be detailed. So it's going to be very hard to enforce. I think there's one case about trying to enforce like a couple of dirhams. It should probably be as detailed as possible with respect to the amount, try and use local currency if possible, the timing, and any conditions that are associated there. The idea is to make it as easy as possible for somebody to read the words and know what it's meaning. The more vague it is, the less likely it's going to be enforced. And that's why having a lawyer review these will also be able to help. So a very important part of this is that even if you have a mahar, even if you signed onto a mahar, you still have the right upon divorce. I'm assuming that this is in a marriage, not in a common law union, right? Because only marriages have these rights that I'm about to say. You still have the right to spousal support, child support, and a share of the family property. So that means I get, upon divorce, both a mahir, I also get my spousal support, I also get my child support, I also get the family property. The dowry is not going to reduce or take away any of your other rights. There is one small addition or complication to that, is that people sometimes ask, well, okay, well, now when we are dividing our assets at the end of marriage, and we need to know, okay, so let's assume that we're going to give 50% to one side, 50% to the other side. Does the mahar count as part of the money that we are splitting up? So is the girl only going to end up with half of her mahar or all of the mahar? And so that depends on the wording of the contract, right? So for example, you know, if it says that the mahar is excluded from the calculation, sometimes contracts will explicitly say that this is her dowry and it's excluded from family property calculation upon divorce. Then that way you can protect your mahar as well, to make sure that the mahar is yours and only yours. That's a very important part to remember, that, you know, when we are trying to see how both of our religious rights and entitlements and secular entitlements are coming hand in hand, we need to make sure that, you know, it's appropriate to get both of them. So from a religious perspective, perhaps you might want to get a scholarly opinion on how you can align your legal entitlements under both systems. Perhaps one person might feel, or perhaps it may be unjust for a woman to get both of her mahar as well as all of these other legal entitlements. That's a religious and moral discussion to have, but legally, there's nothing preventing you from doing that. So I have a couple of examples just to make sure that we are trying to understand everything we've went through. So Ismail and Amina enter into a nikah agreement just before they get married. Their agreement says that if they divorce, Amina will give Ismail custody of their children. And in exchange, he promises he will not object to a religious divorce and he will pay the mahar. I'll give you a minute to think about it, and then we can discuss it. Okay, so the situation here, it triggers a couple of different issues, right? So we said that any marriage contract that deals with issues of who gets custody of a child is not legally enforceable in Ontario. If you remember, we said that you can deal with that on separation, but not in a marriage contract. So you can do that in a separation agreement when you're actually getting separated and when you actually have a child, and when the court can actually assess what is in the best interest of the child, but you can't do that in advance. So you can try and agree to a different custody arrangement at separation, you just cannot include that in a marriage contract. So the other thing is that the court will consider whether the mahar follows the rules of marriage contracts in Ontario to be able to decide whether she can get the mahar as well as her other family property and spousal support. We don't have enough information to know whether, you know, she signed it in the right way, whether she got independent legal advice for it, and all those other rules that we mentioned. And then the last thing is that the court cannot force Ismail to give Amina a religious divorce, right? But the court may not accept any of Ismail's arguments in the divorce settlement if he's refusing to give a religious divorce that he did agree to give. Right? So again, it's not like that promise is completely irrelevant. It is relevant. It's just not enforceable in the way that they might agree to. So these are all things that Amina should really ask a lawyer about when and if she's ever in this situation. And then we'll go to this example. So Mustafa and Maryam were married for 2 years and they've separated. Maryam's father negotiates a separation agreement with Mustafa and signs it on behalf of his daughter, Maryam. The agreement deals with a mahar and with a religious divorce. Will the court say this agreement is legal and enforce it? So again, I'll give you a couple of minutes to think about it. Okay, so the agreement is not going to be enforceable. It's not legal in Ontario because both Mariam and Mustafa must agree, and both of them must sign the written agreement in front of a witness, right? So we said it can't be her father. I know that that's something that sometimes we have in our cultures and religions, is that our fathers sometimes have a big role in these decisions. However, it's really important that it's the spouses themselves. Moreover, even if Mariam signs the agreement herself, let's assume she did, she has to really have the full information about it and feel that she's not being pressured into signing it. So it's not, it doesn't sound like it's going to be automatically enforceable. So one last thing is that sometimes people might feel uncomfortable with entering into a domestic contract, which is highly recommended just in order to know what your rights are when you're entering into a relationship. So it's sometimes provides comfort to know that you guys can agree to change your mind later, right? So let's say at the beginning of a marriage, you enter into contract to do X, Y, Z. Maybe 2 years later, things change. One partner gets a large inheritance. You have a child together and one person's income increases or decreases a lot. There's a lot of factors that can change your mind, right? And as long as obviously both parties are changing their mind together, you can re-agree. Remember, I said that a marriage contract isn't just about a contract that you have before or at the time of marriage, but it's something that you can do after you're married too. And even if you already have one, you can just make a new agreement later. So when you are making this new agreement, if you already have one and you're just changing it, it's called that you're varying your contract. Or if you want to cancel it altogether, you can do that too. It's called rescinding. So sometimes this new domestic contract is called an addendum agreement or an amending agreement, right? So an addendum is something that you staple to the back of a contract. It's an additional paper, or an amendment. Maybe you're changing it in another way. So throughout this presentation, I tried to give an introduction into the different types of relationships that we had, the different ways that you can protect rights through a contract, to not only rely on the default legislation entitlements that you have. And then we were talking about specific issues that arise with Muslims in general. So at this point, I think we can do some questions.
Yeah, thank you so much, Lena, for this very informative presentation. Yeah, now it's the questions is open. If anyone, you can just unmute or raise your hands and unmute yourself and ask your question, or if you prefer, you can write your question in the chat and we'll read it. Wow, you did so great. There's no questions.
I hope that means that everybody understood it.
There is one question in the chat. It's about recording. Can we request the recording?
Yeah, we can. We'll get back to you on that. I think we had a problem in the beginning of the recording. It's missing a part. But yeah, maybe we'll see if we can send the slides.
I do see one question. It's saying, how would the court know if a woman was coerced to sign or didn't understand the contract? Or how would that be proved? So that's a really good question. So like I said before, there's a concept called ILA, independent legal advice. And it's not technically a requirement to be had for every single contract. However, it's highly recommended. And usually if you do have independent legal advice, it means that the woman was not coerced, right? Because it means that she fully understands what she was getting into. So that's one of the ways. The other ways is that, you know, sometimes even if you do have independent legal advice, you can still argue I was coerced or I didn't understand. Sometimes if it's in a different language, sometimes if it was just very vague, you know, these are all things that you would have to obviously work with a lawyer to prove based on each situation. But typically to avoid typically to avoid having those kinds of debates and arguments, what people will do is take independent legal advice. They'll make sure that the wife is going to have her lawyer and the husband have his lawyer review it, so that both sides fully understand what they're getting into. Okay.
There is another question in the chat. Thank you for your answer, Lina. If the husband refused to give an Islamic, before that, how long do couples have to be separated before one can apply for child support, divorce, etc.?
Right. So if there, and we're going to get into divorce later, but there are more than one ways of getting divorced, right? Typically, the easiest way is to do the separate and apart test, right? So if you're living separate and apart for more than a year, then you can prove and say that I'm now divorced. If you want to not have to live separate and apart for a while, you can also try and get divorced on other grounds of divorce, such as adultery or cruel and unusual punishment. So, but those ones don't have a time restriction to live separate. However, those are usually very hard to prove and sometimes might end up taking that long anyways. The idea is to say that, you know, a woman should be able to get divorced faster, but it doesn't always work that way.
Thank you. The next question is, if the husband refused to give an Islamic divorce in Ontario, is there any way the law can interfere?
Right. So if the husband agreed in the marriage contract to give an Islamic divorce, the courts cannot force him to give that divorce, right? However, there are ways that the courts can penalize, maybe isn't the right word, but the court can take into consideration his breach of the contract, right? So for example, when he is arguing a certain argument, maybe the court isn't going to believe him or give him the full credit. Maybe there's certain evidences that the court isn't going to accept. So like I said, the conditions that sometimes women will put in their marriage contract of forcing the religious divorce, it's not fully enforceable. The court cannot say, so-and-so, you have to go and divorce the wife, but there are other ways to pressure him. There is an amendment in the Divorce Act. So this is not only in Ontario, but actually across Canada. And it's supposed to prevent barriers to remarriage. So if you are in a situation where you want to get remarried and your husband won't give you a religious divorce, that the court can try and assist in certain ways. But again, even there isn't a lot of application to it. It's pretty narrow. So it's not something that is heavily utilized. In all circumstances, the court can't actually force him to say you are divorced or whatnot, but the court can try and ensure that whenever he is applying for different types of family rights, that is taken into consideration.
Thank you for your response. And the next question is about a civil marriage application time. When should couple complete a civil marriage application? Before their nikah, during, or after?
You know, that's a very good question. I think typically a lot of religious officiants don't want to go do a nikah these days unless you do a civil marriage. At least, you know, I'm from Windsor, Ontario. That's a practice that's done locally. I'm not sure how it is in other cities, but I think that that's a pretty smart way of ensuring that you don't forget to do it. It's very important that you do get it documented and you do get your civil marriage. So there's no, you know, hard line rule about this, but you just need to know that you will be considered to be a cohabiting couple and not a married couple until that process is done. So personally, I think that it's, you know, to protect everybody involved, it's important to get that done as soon as possible, because let's say that you have your nikah, 6 months later, things aren't going well. Now you want to separate. Well, now you're not married to separate in the way that you might want to. So doing it earlier is probably better.
Thanks again. How long does the application approval take?
So the there's no real approval. Like it's very fast. I mean, technically there is an approval, but as long as both individuals are above 18 and everything's done correctly, it shouldn't take more than a couple weeks max. I know for COVID things were a little bit different because everything's slower in the COVID, but things became a lot faster now and they've picked up the speed. So it shouldn't, I believe, and this is going to depend on each city because every city has different place where these take place. And so depending on how busy they are, you might be able to get it done instantaneously. You just walk in, get it done, and maybe like a week later, you might have to book an appointment that's 2 weeks later, and then maybe 2 weeks later, you'll get it. So there isn't one consistent timeline for the whole province or country. It's really dependent on municipality.
And I also have a question. Who is deciding for child custody? A child?
Sorry?
Who is deciding for child custody?
So it's not the child. If I can ask your question again, are you saying if the child wants to say, I want to live with mom or I want to live with dad? Yeah. So it's not 100% that way. The court is going to ask what is in the best interest of the child and take into consideration a long list of factors. Of course, they will consider what the child prefers, but it's not a decision of the child to be made. It's ultimately a decision of the court to be made about what's in the best interests, because the reason is because practically speaking, maybe the child is just saying that because they're feeling pressured, right? Maybe they're saying that because when he goes to mom, he gets all the sugary sweets, and when he goes to dad, he's not, right? So it's not necessarily 100% the child's decision. There's a lot of considerations that go to it.
I see. Thank you. There is no other questions on the chat. Any other question? You can unmute yourself and ask your question.
I have one that's been sent to me directly, I think. The question says, if there was an affair involved which caused the marriage to break down, are the chances winning the divorce case more in favor of the loyal spouse?
Right. So one of the grounds of divorce, and we will get into this in the session for divorce, but one of the ways is of adultery, right? The problem with it is that it's not a very fast process. It's not a very easy process to prove an affair, right? And adultery means that the affair can't just be chatting, right? It can't just be a moral or emotional affair. It has to be a physical affair. So it's something that isn't always easy to prove and isn't always very successful. And honestly, even if it's successful, sometimes people don't like going through that process. It's a very emotionally and financially draining process. So sometimes it's easier to find another ground of divorce. Like I said, you don't, your successes of whether or not you win a divorce isn't only based on, whether one person was loyal or not loyal. That consideration is there if you don't want to do the living separate and apart method.
Another question about children decision. If the child is 12, does he decide to live with whom?
Yeah, so like I said, and we'll do a whole thing, a whole session on child custody and access. You're right that when a child becomes a little bit older, his views are taken into consideration more heavily than maybe if he was only 5 years old, right? However, still, it's not the child's ultimate decision. Just because the child, doesn't matter if they're 3 or if they're almost, if maybe they're 18, it's not their sole decision. Yes, the older they are, the more mature they are, the more the court will be able to say, you know what, he's making a reasoned decision, and that should have an influence over the course of his life, really. But it's not 100% something that the child is only unilaterally able to decide on.
Thank you. Any other questions? This question is also asked one more time. Our participants wants slide information. Is it possible?
Yeah, inshallah, I will share these slides, the updated slides. And for sure, sorry if I was also speaking too fast. I know that sometimes it's hard to grasp everything really fast. So I'm more than happy to share all these. As well, there are, at the end of the slide deck, I did include some resources to other links that may also be helpful as well.
I just want to add that through the Muslim Legal Support Center, you can visit their website, and if you need any advice from any lawyer, you can, like, there is a form there where you can fill it up, and they can assign a lawyer where you can get some time to answer your question privately. So it's a service provided by the Muslim Legal Support Center. It's right, if you wanna say anything about that.
I just wanted to say that, please, if you have any legal issue or challenge, come to us, fill in the form, and we will try to find a pro bono lawyer for you who can provide you advice, phone advice for 30 minutes. And that's what we can offer at the moment. So please take advantage of that. I hope that you don't have any legal challenge at all. I hope you all live in peace, but we all don't live in an ideal society, right? And things happen. It's not our fault, but things can happen, and we all have problems from time to time. So take advantage of the service, and that's all I have to say on that. But Lena, I have a suggestion. Some of the examples that you provided, those are very good. I was wondering, maybe for future references, if you could provide a example, a template for contract, so that people can see, what's in there, some examples, and that might be useful for lay person like me. I'm a visual person, so if I can see that, it's easy to it draws attention to the issue and what we should be doing. So please add that in your future presentation, so that a layperson like me or others who don't like to read text, they can take advantage of that. So I'll stop, but we have an evaluation form which I shared in the beginning. Please fill in that form and let us know how can we improve these sessions, what can help your life. Okay, so I appreciate you giving us an opportunity to collaborate with Wisdom and her organization and Coalition of Muslim Women's Waterloo Kitchener. It's a mouthful, but that's what it is, right? Thank you.
Thank you. It's right. If you have the link to the intake form handy, can you?
I don't have that, but I don't have that right now. But I have the evaluation form that I can share.
Okay.
But people can, you can just send us an email, and I can quickly send you the form.
Thank
so
you.
this is the evaluation form.
We have another question on the chat. What is the legal process of an annulment?
Maybe we'll save it for the session on divorce, because that'll go very nicely with that, inshallah.
Yeah, thank you.
So, Lena, so your advice is for everyone who comes here in Canada or to have a civil marriage, yeah, or stuff like even because sometimes we think that if sponsored by my husband or sponsored by the other spouse, we don't need to do that because it's already there in the paper. There is an evidence and there's marriage certificate and stuff like that. So what is your advice?
No, like I said, you are not married in the eyes of the court if you do not get a civil marriage. So, getting a paper from your mosque or from your imam or from wherever you think, getting that other certificate doesn't mean that you're married. And so definitely everybody needs to get civilly married. Like I said, when you are cohabiting, you're not married, you're only common law union. And then at divorce, you're gonna have to prove and fight for every right that you want. You're gonna have to prove that, this is a serious relationship. And even then, you're only entitled to a limited number of family rights. So it doesn't protect you at all. Even if you have the best cohabitation agreement there is to be, it's usually not an alternative for actually getting married. But at the very least, it is something that should be had. You should never be in a relationship where you're neither civilly married nor have a cohabitation agreement. That is the worst, right? We need to make sure that there's something there to protect you upon separation or divorce.
And is it the same case if like one of the spouse is deceased? Like it is the same case if like I won't get inheritance or all those kind of things if I'm not civil married?
Yeah.
So different.
Yeah. So like if I am only religiously married and not civilly married, and my husband passes away, I will not get his inheritance or the inheritance that I'm entitled to because I'm not married. At the end of the day, you aren't married. Being in a common law relationship is not an alternative to marriage. So a lot of the other types of entitlements, even like it affects everything. It affects your ODSP, it affects your immigration, it affects a lot of things, even outside of the direct family law applications that we cover today, right? So today we went through what happens upon separation. So maybe your property assets, your children, your parental rights, those kind of things will be treated a little bit differently. But what about even everything outside of the family law realm? There's a lot of other things that will be influenced on this distinction of being married or common law relationship. And so it is something to take seriously and make sure that we all take steps to get civilly registered.
Thank you. Thank you so much.
You're very welcome. Thank you.
If you have a official legal marriage certificate from another country, do you have to go through any process when you land in Canada, or is it recognized everywhere?
So as long as it is legally completed in the place where it was done, it should hold over here. And we'll talk more about it. There's going to be a whole session about immigration. I believe it's the last one. So we'll go through the details of that. But the short answer is that it will be valid. You don't have to start from scratch.
Good to know. It's all really very important information. Some of them are very new for me personally, and yeah, I think it's all connected to each other, but we have to wait until to give it the right time, enough time to discuss it. So each topic is going to get more of a detailed information, inshallah. Yeah. So if we don't have any other question.
Don't forget the evaluation form.
Yeah. Okay. So I think if there's no more questions, we can wrap up here the session. I'm trying to wait a little bit. Maybe someone has last question. I don't think so. Anyway, thank you, Lena. That's mean you did a great job in just bringing all the information needed. Thank you so much, and thank you everyone for joining us today. Thanks. And we're waiting to see you next session. Don't forget about that. If you didn't register for that, please do. And there will be always a reminder email just before the session. Thank you so much. See you next time. Have a good evening.
Have a good one.